Welcome to the Winner's Playbook with Steve and Josh. Disclaimer: the information contained in this podcast is general in nature and does not take into account your personal circumstances. Please head to the show notes if you wish to book a free 15-minute call to discuss your personal situation.
All right, welcome back to the Winner's Playbook. I am Josh Lee, and today I'm here with a very special guest, Benjamin Bryant. Ben is a family lawyer at Bryant-Mckinnon Lawyers who is passionate about helping his community deal with challenging family issues. He always thought he would find himself in a big city, but ended up staying local as a partner at his New South Wales-based business and has been helping his community ever since. Ben, welcome to the Winner's Playbook, mate, and thank you so much for joining me today.
Thank you, Josh. It is great to be here. I think a lot of people think if you don't live in the city that you haven't quite made it yet, but I'm here to tell them that people actively choose to live in the regions.
Yep. No, I think, we were sort of touching on COVID just before we got on here, and I think some of that has definitely sped that up, and so many Victorians actually left Victoria for that exact reason and have moved out to the regions. So
Absolutely. It was clear that we had completely different experiences of COVID.
yeah. No, definitely. But keen to jump into it, mate, because I always talk a lot with my clients around this concept of having your dream team in order. And what I mean by that is for people to sort of tackle any part of their life, they have the right people on the team with them. And who I sort of put in that dream team is the financial advisor, the accountant, the mortgage broker, and then the final piece is then the lawyer. And then if you have those four people on your team, you should be able to tackle most things ultimately in life. But obviously, you sort of specialize in a particular field on the legal or law side of things, which is family law. So if we can kick it off, then Ben, could you tell us just a little bit about what's kind of drawn you then into family law, a bit about yourself and the firm that you guys operate?
All right, thanks, Josh. And look, we get called a lot of things as lawyers, but being part of the dream team, I haven't heard that one before, so I'll take that for sure. Look, I kind of fell into family law. I don't have any romantic story about wanting to help community or being involved in the family law proceedings myself. Early on, I was just a college graduate and then moved back home to Coffs Harbour, was staying with my parents, and I thought I'm just going to have a bit of a gap year. Then, of course, after a few months, I got bored, put my resume around the local businesses, the local law firms, and out of all of them, one person responded, and that was a sole practitioner who practiced mainly in family law. When I started off in family law, I didn't really know anything. Sure, I did family law at uni, but I didn't quite get it, and the scenarios were just silly, like Jack and Jill were married and things like that. I didn't really relate to that at all. But working with my first employer really opened my eyes to family law. And next, I did my master's in family law. Then I became an accredited family law specialist, and now I have my own law firm here in Coffs Harbour, Bryant-Mckinnon Lawyers. And like I said, we focus on all things family law here, which is divorce, which is parenting arrangements for children, which is property settlements and things like that. We do wills and estates and conveyancing and other things like that, just so we don't have to push our current clients away to get those services through another lawyer. But certainly we have the blinkers on, which most lawyers do these days. I think, to be fair, there's I can't say there's not many general practitioners around, but it's getting less and less. And people, much like yourselves, you focus on a particular area.
Yeah, and so family law is definitely like a niche area in your space, and that's an area where you guys essentially specialize in.
Absolutely, yes.
Yeah, amazing. So if we then talk to a little bit about, I suppose with us, a lot of people sometimes come through to us and think they need a financial advisor. Sometimes they don't actually need a financial advisor, but there are sometimes key sort of signs or signals that sort of go, yep, you're in a position where you could actually benefit from getting some actual advice. I'd be curious to understand of how do you sort of approach that from your side and put your lens on of like, when does it make sense to say engage a business like yourselves? When should you do it? Do you need to have a certain level of assets or in a certain situation? Obviously, probably being in a relationship is going to help from that respect. But yeah, are there any sort of like, times where it's like, yep, you should be speaking to a family lawyer?
Yeah, I think it's what I'll say for me is my advice is the sooner the better. But of course, your listeners will say, "Oh, of course he's going to say that." But I'll explain myself. Is that
Yep.
there is a difference between legal advice and legal representation. Lawyers do get a bad rap that if you go and see one, then they're going to drag you by the arm, they're going to empty your wallets, they're going to force you to go to court. But that's not the case, especially not in family law. There's a real focus to try and get people to resolve their matters outside of court as timely and inexpensively as possible. Yeah. So the key is to get legal advice early on, because what you're trying to do is you're making some pretty important decisions at a pretty hectic time in your life. So perhaps you need the dream team, like you said, to get that advice. So when you're making decisions, they're informed decisions. I think in terms of markers that I would look for, Josh, I guess, is in terms of whether your matter is perhaps a little bit different to the stock standard and you really need to get someone involved. I guess, of course, in circumstances of safety, the Family Law Act has just been amended to really focus on safety. The family law, has always considered safety as a priority, but the legislation has just been really cleared up at the moment to make sure people are safe. So if there is issues of safety, then of course you need some support in that sense. Circumstances of urgency as well, which could be a financial urgency or could be perhaps a parenting urgency. They've got passports and they said, I'm off to Mexico and you're never going to see your son again. That's when obviously you need to see a lawyer at that stage. And the other two really of things that I look for is communication. Is there the absence of communication or is there too much communication? In the absence of communication, it's likely that someone is beating themselves over the head. They're just so frustrated because there's just not, the other side's not the negotiating table. They just have their head in the sand, and that's very common in property settlements. For example, someone has to move out of the house. They know the house is going to be sold. They're never going to have the dream home again or live in this area again. So they'll dig their heels in and stay there as long as possible. The other circumstance, of course, is too much communication. Sometimes we see people and they've been probably separated for 2-3 years and it's going back and forth. And if you keep doing the same thing, you're not going to get a different result.
Yeah, no, it's interesting. So are you tending to find that people come through when, I suppose, shit's kind of hit the fan, so to speak? Is that sort of when you're usually getting involved, or is it a lot of prior to that where you can try and clean it up?
Well, mostly the shit has already hit the fan, right? That's when people get involved. And I guess it's still true that if you're seeing a lawyer close to separation, I guess it's probably an emotional thing, right? What you're doing, you're lawyering up. You want to punish them, or you want some form of retribution, or they've got a lawyer, so now you want to best them and things like that. But so that's how a lot of people do it, Josh. Absolutely. But look, I also get people. You get people on the other side of the spectrum that are just about saying, look, we're fine. We don't have a disagreement. We can communicate really well. There's no issues whatsoever. We're really just respecting each other's boundaries, and we just want a sensible way forward. Look, only Gwyneth Paltrow can pull off a conscious uncoupling, right? If it hasn't hit the fan by the time they've seen a lawyer, it's likely a ticking time bomb. Not many people can pull it off, and it might be that there's a new partner involved or something like that, and then it hits the fan.
Yeah, so would some of those situations be it goes sort of keep civil and calm, and you're just operating, doing a bit of mediation in that sort of a situation? Is that kind of what your role would be, or?
Sure, and I guess when you say mediate, Josh, I think you're referring to some facilitating negotiations and communications between the parties. Absolutely, that's what lawyers do. Like I said, the system is geared up that way to try and keep people, make sure out of court, make sure court is the case of last resort. But also mediation has a formal sense as well, a formal definition, whereby the courts require parties to attend with a formally recognised mediator to negotiate their parenting or property disputes before entering the court system. So there's that aspect as well.
Yeah, and I don't know, could you say off your head possibly, like, of cases that come through to your business, like roughly percentage of them that sort of settle in the early days versus go the full-fledged court option?
So I can't give you that percentage about who goes the full, the full court, kind of option, full-fledged court option. But I will say this: out of separated couples, the stats show us that only 3% require a decision from a judge. That's how
Wow.
low it is, which is mind-boggling. Because
Wow.
what happens is people, use the court hopefully as last resort. They go to
Yeah.
court. In parenting matters, normally you kind of need input from a social science perspective, like a court counselor or a psychologist or something, to say what's happening with the children, because the parties have their own version of events. You have two lawyers, and then you have a judge who's another lawyer, and all the lawyers are here talking about these kids.
Yeah.
But what they really need is an independent view from someone that's going to be actually child focused. And so
Yeah.
you get this report, and it makes some recommendations what could be in the children's best interest moving forward. And
Yeah.
that's where the matter would likely settle.
Yeah.
In a
Sure.
property matter, it might be about, you can't agree on, one person says the house is worth $1 million and the other one says it's 1.5 million.
Yeah.
Or perhaps there's no disclosure. It's very common for one party to have no knowledge of the finances or very limited knowledge, and the other party know everything.
Yeah.
So sometimes you might need to get those boxes kind of ticked and get disclosure and valuations and things like that, to iron out the issues, and then the parties reach an agreement. So just because you go to court does not actually mean that you get a decision from a judge.
Yeah, sure. And I take it that just means more dollars are being spent when it's going to court, and then the time to get a resolution is blowing out. Yeah.
Absolutely. Look, the court
Yeah.
promised all these things a couple of years ago, about making it a more streamlined and cost-effective systems, and to some extent, it has gotten better. But you could expect, at least in this region, you could expect to be at a court for a couple of years. You can
Wow.
expect to spend, tens of thousands of dollars on lawyers. In the city, sorry guys, you can spend hundreds of thousands of dollars
Yeah. Wow.
on lawyers. It gets very expensive, but
Yeah.
like I said, it's geared to try and keep people not necessarily out of court, but
Yeah.
outside of the courtroom doors, in the sense of not actually needing a decision from a judge.
Yeah.
And look, and the way the system works now is that you could be 1 year into the system or something like that and actually never go before a judge. You're actually before a registrar, which doesn't have, who
Yeah.
don't have as many powers as a judge, but they
Yeah.
can do timetabling. They can, make sure valuations are underway, disclosures happening, or decide interim parenting arrangements for children and things like that. A lot of people actually never get before a judge because that doesn't come till right at the end. It is not judge duty, people. You don't just rock
Yeah.
up, wave your arms around, and it's all done in a
Yeah.
day, unfortunately.
Yeah, wow. No, that's it's astonishing to think about some of the money that can be thrown into this stuff, and I'm sure there's been some cases out there, and I think in some respects, is it, would there be some situations where there's just that much money going into it, where did people get to a point where it's like, hey, like we're spending this much money on it for what exact reason? Where we're trying to split the assets or whatever it may be, but the bill's just racking up, and then is it just ego? Like what is that at some points? Is it a bit of that, like?
Look, it's the human condition. It is
Yeah.
conflict, right? And look, and
Yeah.
again, people have this idea that lawyers are there, taking people on this journey for their own benefit, but that is not the case. We literally spend all of our days, shaking clients, getting them to see, because if I've done my job right, nothing will happen at court or nothing will happen in the matter which I haven't already explained the options. So if there was an outcome received by a judge handed down a decision, the client would be like, oh yeah, you've already talked to me about that. Do you know what I mean?
Sure.
So it's why people do it, I'm not sure, but we always try and get them to see the whole picture, not just what's in front of them. And we always talk about what the future looks like, in terms of the proceedings, like how much money the next court event's going to be, what the likely outcome is, all these things combined. You're arguing over children, you're spending 60 grand between you. What could you do with your 60 grand?
Exactly.
Do you know what I mean? So it's, you're doing a lot of reality testing, and that's the lawyers doing that. The judges also do that as well, but it's the human condition.
Yeah, wow, no, that's amazing. Well, getting on to something else then. So talking about divorces, and you always hear divorce, is it 50-50? I've seen, a few divorces over the time as well. And I know, in fact, it's not 50-50, but how do you best approach that? If someone's walking in the door, they're, looking at splitting up, how do we best go about doing this? Are there any guidelines that you generally would go by, or is it really is it case by case in terms of how that split of assets could look between, example, husband and wife?
Well, look, I'm going to give a very legal answer, and it is, of course, a case by case, but there is also general guidelines as well.
Sure.
To your listeners, no, there's no automatic 50-50, and always be careful talking to family and friends. And I get it every single day, is that my brother went through and he got, ripped off, and or I had a friend and they were entitled to something, but it's not one size fits all. It doesn't, there's nothing in the legislation that says, if you were married for 17 years, you have 3 children, the husband is the primary income earner, and the wife, has rheumatoid arthritis, then the division should be 57% to the wife or something like that. It just doesn't work like that. But what the court does, what the Family Law Act has done, is essentially set up a pathway for a court to make an assessment what is a just and equitable outcome, what people commonly call fair, right? It's not quite the same, but let's just go with that. And when I'm talking to you about what the court would do, I'm not suggesting for a minute that the parties have to go to court.
Exactly.
But whether your listeners and their spouses, or two separated couples reach an agreement, or whether there's a decision handed down by a judge, the outcome should be the same, or it should be similar, right? They need to know what was likely at court for them to be able to negotiate outside of court, right? And that's where the lawyer comes in. Okay, so the 4-step process is: step 1, identify the assets and the liabilities. So that is what is up for grabs now. Don't draw a line in the sand, who had what at separation or who had what at the start. It is just what is up for grabs now. Nice and simple most of the time. Step 2, we're looking at contributions. So we are going back in the past. We know it's up for grabs now, but how did it get there? Who had what at the start? Who did what during the relationship? Were there any windfalls received in the relationship, like contributions from parents or TPD claims, things like that? Step 3, we're going to leave the present, leave the past, and look into the future. What is the future needs of the parties moving forward? It might be income disparity, it might be parenting arrangements of children, it might be health or something like that. And the 4th and final step is, again, just stepping away and making sure that the outcome proposed is just and equitable. And an example that's pretty crude, Josh, but I give it all the time, is that there's $1 million up for grabs, $500,000 of cash, $500,000 of super. So parties agree, the wife get $500,000 cash, the husband get $500,000 of super. On face value, that's 50-50, and let's say in the circumstances that's fair. But it's actually not just inequitable, because the husband is walking away with an asset with all these strings attached, and like if the parties are in their 30s and they can't access his superannuation until 65, what's the point of that? Do you know what I mean? So that's just a crude example that I give of what is, just and equitable. So that's essentially the pathway that the court follows. And what's funny, the irony is that I have some people come to me saying, we just want 50-50. I do the big spiel like I just did then, and then all roads lead to 50-50. But again, it's not just because 50-50 because that's the starting point or that's the automatic go-to. It's 50-50 because we just went through that 4-step process.
Yeah, no, God, I've got a heap of questions off the back of that one. So it obviously, and then when you get, if it doesn't go to the courts and say it's just a matter of you're facilitating the conversations and the parties are then agreeing, is that then a document that would then be signed off? Then parties all sign that, or what happens there?
Ideally, Josh, yes, that is what happens. If parties reach an agreement in respect to property matters, then yes, you can do what's called an application for consent orders. And in that, there's essentially 3 people certifying that it's just and equitable. 2 of the people, of course, are the parties, normally the husband and wife, but the other party, of course, is the court. The court needs to be satisfied that the orders that the parties are seeking are just and equitable. To do that, there's 2 documents required. One is a minute of consent order, which sets out who is to do what and when, so transfer of a house or superannuation or something like that. And then the other document is like 30 pages. It's an application for consent orders, which sets out essentially the 4-step process.
Yeah, wow. So it's not as simple as I thought. I thought there might be a way of doing that in a simple manner.
Look, you can do it in an informal situation. People do, because some people say, look, we agree we're going to sell the house,
Yep.
we're going to split it 50-50 and walk away. And then the
Yep.
lawyers say, you shouldn't do that. And of course, the lawyers are saying that because we just want money and we want to make conflict. But that's
Sure.
not the case. If the parties do agree to do a hand-on-heart deal, that's okay. No one's going to get involved. That is their prerogative. But it is the lawyer that will tell them 10, 15 years later that that wasn't actually a property settlement at all. And then I had a case a couple of years ago where there were circumstances where the parties did just that, hand on heart deal, sold the house, split 50-50. Problem was he was a low income earner and had about $30,000 of superannuation. She was a nurse on the old scheme system. And so at the time, her superannuation was probably around $80,000, $100,000 or something like that.
Yep.
But 10 years later, worked out when she was calling in a super that it was worth close to $1 million.
Sure.
He said, well, I want half of your superannuation as it is now. She said, no, I'll give you half of my superannuation as it was when we separated. And the outcome was somewhere between that. So a hand-on-heart deal, we don't need the lawyers, we don't need to lock it in, is not a property settlement. And whilst there are some time limits that apply, but if the parties remain married, there are no time limits. It can be very complicated with repartnering and buying another matrimonial home and doing it all again. But it's not a property settlement. So going back to my earlier advice is get legal advice. You just get information so you can make informed decisions.
Yeah, I was going to say, so even in situations, say where there is no property involved, maybe you just have hubby and wife, they've both got a superannuation, there's some cash, there's some cars and bits and pieces there. Even in those situations, still getting it done up and seeing a lawyer, like seeking a lawyer in that situation, like can make sense?
Yeah. Well, look, it depends on your personality type. If you're the person that is happy-go-lucky, who knows what the future will hold, we'll just play it by ear, then perhaps just, splitting it between yourselves and walking away is okay. And if shit happens again, shit happens. But if you're the type of person that wants your ducks in a row, do you know what I mean? Then that's not sufficient, especially when things happen, because the irony is there's no crystal balls, right? In family law, we can only deal with what's known, the known entities. One of the things is that if you do separate and you divide your stuff as you guys think it's fair, but don't do a property settlement, but then the tables turn or there's a change of circumstances, like someone becomes unwell and before they were the primary income earner or the higher income capacity person, and then they're out of work. Or it could be that their parents pass away and they inherit $3 million. Or it could be someone's very lucky and they win on the scratchies or the lotto or something like that. And there's a change of circumstances. And when there's a change of circumstances, there can be a change of heart. And if if you've only done the hand-on-heart deal, then sometimes the gloves come off. And look, I hear all the time, he wouldn't do that. Or, we have an agreement. There's no issue. We still have our daughter together. It's much easier and cheaper to nip it in the bud when you're in the moment, rather than waiting for problems to come later on. Absolutely. Because if you may choose to walk away, I don't want any of his super, or I don't want to go after the inheritance, and that's okay. The lawyer's not going to make you do those things, and the court's not necessarily going to make you do those things either. But if you're doing it, you need to know what you're walking away from, and then making sure that the legal outcome reflects your intention.
Yeah, no, it sounds like, it's essentially leaving the door open, just like even a little bit for the future, and then, that could all fire back up. So, no, that's great. That's great, Ben. And just one final one more before I move off that part then. I think I know the answer to this, but you said, there's no clear-cut way. You go through that 4 steps in terms of figuring out the division of assets. But other than situations where it does end up like 90-10 leaning someone's way, like it's very severely leaning towards one person versus the other, like that can happen?
Absolutely. No, it can. And that can happen in circumstances like I don't want to say less likely, but more commonly, let's say, in that step 2, the contributions assessment, rather than step 3, future needs. Step 2, that would be, I would say common, but a significant adjustment would be common if, for example, the parties' relationship was a short, it might be 3 or 4 years, in which the court is more mindful to look at financial contribution rather than, if it was a 40-year relationship, you had 3 kids together, the court is probably less inclined to be so focused on who earned what during the relationship or who had what at the start. But if it's, 2, 3, 4 years, the court is very focused because the assets aren't going to be that much different to what they were 4 years ago. Yeah. So if it's a short relationship, don't think that the starting point is 50-50. What the court may do is start, saying if one port, like you said, 90% and 10%, the court might say, well, that's the starting point. And then over the course of the relationship, why should that be changed? I mean, why is it just inequitable to move away from that? Another common one would be the input of capital. Yeah. So it's not the typical penniless couple where, they get together shortly after high school and they grow their empire together. It is someone absolutely bought something, perhaps at the start, because they already accumulated capital, or that maybe there's an age disparity and, they've never done a property settlement before, who knows? But they come in with assets, or perhaps there's a windfall, for example, an inherited property or a gift from a dear aunt or something like that, which really not only injects capital funds into the relationship, but also the parties use it as a springboard because but for that windfall, we wouldn't been able to buy the house or the farm or the superannuation entitlements. And without it, there'd be nothing to divide.
Yeah, well, they're naturally leading on to that then. If you have those situations where, say, one party in the relationship is coming in with substantially more wealth or they've got more money, whatever it may be, and then we're deciding that we're actually going to get married, I get asked this question so often around prenups and are they worth it? Do they even hold up in court? I'm very keen to understand how can they actually protect? Do they actually make a difference, or in the end, can that be ripped up and the judges or the courts are going to decide what happens?
All of the above, Josh. Again, very unhelpful answer. But look, the Family Law Act does provide the capacity for parties to enter into a binding financial agreement. That is, the law allows for it, absolutely. The law calls it a financial agreement, but if it jumps through all of these particular hoops and meets these particular criteria, it does become binding. And there are a lot of successful binding financial agreements because they're successful in the sense of parties aren't disputing it. They're like, oh, we already sorted out who's going to get what. Before we got together or before we got married or something like that, then we don't need to go see the lawyers. We just do it ourselves. And it's, the court never hears about that, and the public never hears about the successful ones, right? Where they're uncontentious. But what we hear about all the time is the unsuccessful ones, and there are a lot of them. And look, the reason why it is because I mentioned the crystal ball before, is that prenups are really good at saying, look, I have this at the start. I'm much more wealthier than you. And I want to protect that. I want to quarantine. I want to isolate that. You can't touch me type of thing, right? And it also says, look, we don't know what the future holds. We don't know if we're going to have kids. We don't know if one of us is going to get a cancer diagnosis. We don't know if one of us is going to maintain their income earning capacity. We don't know any of those things. But to hell with that, I'm more wealthier than you, and I want to protect myself. And the court, by its very nature, is a court of justice and equity, as we have discussed in that 4-step process, right? The court is very focused on that. So if it gets an opportunity to rip up a binding financial agreement, then it likely will. Because the intention of a binding financial agreement is, to hell with the Family Law Act. We don't need 40 years of jurisprudence. We don't care what the rest of society is doing. We've got our own good thing going here, right? And most of the time, it's wrong. Most of the time, there is a superior party. And I get people come to me saying, look, I've been presented with a binding financial agreement. My husband or my wife wants me to sign. I'm happy to go with it, right? I'm happy to go with it because yes, they do own more than me, and I accept that. But my question is, and it's usually met with silence, is what if you don't sign it? What is the consequence? What does that say about your relationship if you don't sign it. Do you mean? Because you're getting really right to the crux of it. And if there is a
Yeah.
if there's a problem, and not a problem, but if there's a, let's say, a disparity or an imbalance in dynamics in the relationship or personalities, as there always, I can't say always, but there usually is, therein lies the problem. They are the people, the inferior party, as it were, are the people that need the protection of the Family Law Act. Most of the time, they should not be saying, I don't need it, we're doing our own thing, thank you.
Yep.
So I always ask people, what is the consequence of you saying no? That's the real question. Yeah. So it's look, it's difficult. We personally don't do them. It's very, very risky for family lawyers to do them. Okay.
I was going to say,
Because
are they very common? Do they get done up too often, or is it kind of like a thing you always hear about, but no one really does them?
Well, look, in this, I haven't got the stats on it, Josh, but speculating, the cases that you'll read about, binding or perhaps not so binding financial agreements would likely be couples living in the city, people that are, where the stakes are high, where they're happy to spend money on litigating and things like that. In regional New South Wales and small Coffs Harbour, they're not a huge feature. But the problem for the lawyer is that they're so risky, because I mentioned before that they're financial agreements. They're only binding if certain criteria are met. And if I didn't cross the T's or dot the I's, or if I referred to the wrong section, and if I forgot, to sign page 7 or something like that, which can happen, right? And I act for example, the superior party, then 10 years down the track, if the court says, well, we're ripping this up, this, it doesn't meet the requirements, it is not binding, then of course my client is going to be looking to say, well, hey, this was our intention. You gave us a dud document. And so they sue the lawyer. Okay, it is very difficult. We've made the decision in our firm not to prepare them. We do advise on them. We're happy to sign off for people to say we've given the requisite advice, because that's one of the features, one of the requirements to make it binding, is that the parties have read and understood the agreement and aware of the advantages and disadvantages of the effect and the impact of going into the document. So we're happy to advise on them, but we certainly we will not pen them ourselves.
So I've heard of them a few times, and would it be more of it, like you said, like the inner city firms, or those with more wealth would typically, say an example, say I come from a really wealthy family, of which I certainly don't, but say I do, and then my family wants to protect that wealth, that then I'm going into a new relationship with someone, and would it be probably more the family above forcing, like, say their son, me, to say, look, you're meeting this person, we want to protect the wealth, keep it within the family? Is that kind of where they can come about? Or?
Well, look, Josh, I also don't come from a wealthy family, but so I can only speculate like you. But look, I guess a lot of it is that. But again, a lot of it is, I said before, the human condition. What's mine is mine, and they want to try and hold on to it. And I've worked so hard and all these things, but like I said to you before, there is already protections in place. And this is what we say to people, because we do get people, of course, that come and make an appointment with a family law specialist, wanting to quarantine their assets. They want to protect themselves with a binding financial agreement, because everyone knows about them, right? Celebrities make them famous all the time. So when people come to us about that, what we say is that you are already protected. Remember, I went through that 4-step process. At step 2, let's go back in time and see who had what at the start, what were the financial contributions and the windfalls throughout the relationship. So what we say to people is that, look, sure, you without a binding financial agreement, you don't get the finality. You don't get it written in writing that this is what happens. But as we say to people all the time, do you mean just because it's in writing doesn't mean that's actually what's going to bear out? Read the case law. Do you know what I mean? People rip them up all the time. But what you can do is you can take steps to make sure that in circumstances where you do separate, and then you may be, in the witness box, 20, 30 years later, trying to explain what assets you had at the start, and you need the evidence for it, then if you have things like valuations of the houses at the time,
Yeah.
if you have disclosure, like you say, I had $300,000 in my superannuation, make sure you have a superannuation statement. So do
Sure.
your homework. Do you mean get the documentary evidence? If you want to, you could do like a bit of a table of assets, which we call a balance sheet, right? That kind of sets it out. You can get parties to sign it. It's not legally binding, but there it is. At that date, there's your signature, there's mine. We agree that this is what was up for grabs. And we agreed on that because we got the valuation for my house. We've got the superannuation value for my super. We went out and got a red book value on your Toyota Camry, whatever the case may be. Do you know what I mean? And there it is in writing, and there's the evidence already. And that will provide some protection for you. The stuff like windfalls during a relationship, that's pretty common these days because it's pretty easy to evidence, I should say, because we have a paper trail. Mum and dad transfer $100,000 in your account. There's your NAB statement. Do you know what I mean? Or if you receive something, a TPD claim or a workers' compensation claim or something, there's documents that go with that. So it's not like, oh, just trust me, I received $300,000. Do you know what I mean? There's evidence to prove that, and there's already protections in place. Sure, you can't smash the crystal ball. There's still the future needs part, but it's not as if the court's going to say, well, because there's an income disparity, the fact that you owned everything and it was only a short relationship, that doesn't mean anything. Do you know what I mean? It's 50-50. Do you know what I mean? That just doesn't happen.
Yeah, sure. And if you don't mind me throwing this one at you, because we do a lot of work with clients around structures and family trusts in particular. Can you touch on with a family trust, and does that provide any sort of protection with this family law side of things, or can they just be sort of ripped up and it doesn't provide any protection? Or
such an easy question to ask, Josh, but such a difficult question to answer.
I can imagine.
It depends. Family trusts are common, but also so is their intention. If their intention is to essentially minimize the pool, then the court can, raise an eyebrow and say, hang on a second. The court does have powers. It can go back on particular transactions. It can, join third parties, the appointer of the trust and things like that. So the court certainly has the power. So don't think, it's in a trust, then it's completely separated. There's nothing to see here. Certainly doesn't work that way. But there's plenty of case law which upholds family trusts, saying that the spouse who is a member of the trust is just a beneficiary. They're discretionary. There's a long history of them not receiving a dividend or any benefit from the trust. They don't make any decisions. The appointer or the trustee of the trust is also of sound mind. They're removed from the spouse party and all these things. And then the family trust is absolutely upheld. There's also a lot of case law when family trusts, even though they're designed very well, the court sees straight through them and sees that it's just a puppet, essentially of the spouse member. So it's on a case-by-case basis. If you're getting to that stage arguing about the trust, you're probably getting into very expensive litigation. But look, people try all sorts of things, but then at the same time, there's some real legitimate purposes for having a family trust. And a lot of times, things are set up, to disguise, particular gifts or perhaps non-gifts and things like this. But a common one, that we find is that, for example, not even necessarily a trust. It might be maybe a loan agreement is put in place or something like that, because your parents win the lottery and they gift their children, there's 3 children, they gift their children $1 million each. The one that's going through the family law dramas has a loan agreement in place, and mum and dad was just lending them those monies. The other 2 siblings, absolute gift. So, it's tricky.
Yeah, and so because I've heard of those loan agreements before as well. So in those situations, does that actually provide protection when gifting money to, say, kids? If it's a loan agreement rather than just a genuine gift, that provides that protection.
It can, absolutely it can. And again, the court does have the power to look at it. It can
Yep.
join party to it can do all sorts of things, but it's on a case-by-case basis. Sometimes there's loan agreements for legitimate purposes, and when it can be a legitimate purpose is, if the parties are actually been making repayments, or
Yep.
if there's interest that's been accumulating, if there's been, not necessarily formal statements, but reminders saying, hey, just remember that, 150 grand I owe you. If you're thinking about selling your house, I want that back. Things like that. But, agreements where, there's the dodgy ones that just say, I provide the principal sum of this much, and then no interest is accruable. It's
Yeah.
not ever due. There's no due date until I call it in. And there's nothing. And so they're normally seen with a lot of skepticism. You'll be surprised by the amount of time we get those.
Yeah.
But look, yeah, it's a case-by-case basis. And it also, sometimes it's not just the document itself, it's the circumstances and the facts around the document. Some people try and backdate. Some people don't even bother trying to backdate. They try and legitimize debts, that even outside statutory limitation periods, and say, oh yeah, 10 years ago, let's draw up a loan agreement now. There's all sorts of things. People try all sorts of things, Josh.
I can only imagine you've seen it all. It's so similar to like what we do. Like there's just no clear cut solution ever. Like there's no off the shelf cookie cutter situation that, yep, this is you, perfect, it's going to go through. It sounds so similar to what we do.
That's right. And I think, as advisors, all you can do is lay out the options, and ultimately it's up to our clients to choose what they think is the appropriate option.
Yeah, no, I agree. And just one final question then before we bring it all to a close. We do a lot of work with business owners. I personally work with a lot of business owners. I am a business owner in partnership with Steve Sloan. He normally does the podcast with me. How do you see those? Do they add a different sort of dynamic to the family law situation when there are businesses involved? And if I'm going through a divorce in my relationship, there's a business I'm exposed to various businesses and I'm involved with, does that add another layer of complexity, or is it simple as you still go through those 4 steps and this thing just works out?
Well, again, both. All matters go through the 4 steps. All matters go through the 4 steps. A lot of people think, their case is different, or perhaps that because they have $40 million in the pool and they're these amazing lawyers or doctors or whatever, that their matter's different. Not true. All matters go through the 4 step. All matters have to be, resolved or have an outcome with a just and equitable solution, right? Or outcome. Look, partnerships, business owners, business entities, things like that, they are complicating factors. In a family law setting, I guess the most complicating factor is trying to assign a value. Family law values can be very different to different types of values. Much like, for example, if your house was being valued by Westpac for the purpose of a mortgage, would be different to how a real property value would approach a valuation for family law purposes, right? In terms of that market arm's length transaction. There are complexities to it. Certainly, there are complexities in terms of the setup of businesses. Is it a company? Is it a trust? Is it a partnership? Is it a partnership of 2 trusts? Or all sorts of things which do make it complicated. Fortunately for me, I don't have to work through those complications in terms of value, because we have valuers to do that for us. We have, essentially we use all the time, perhaps part of the dream team for me, is forensic accountants that are prepared to look at the financial statements, look at the entities, do their own research, and also, this is the hard one, front up at court and justify their findings as well. We use those types of valuers to ascribe a value for us. Not only do you have to get a valuer to value, but you also need information or advices about what is the impact. What is the impact if, for example, if one of the parties was a shareholder, or was one of the partner in what might be 2 partnerships, it might be a partnership of 4 or something like that. What is the overall impact? Are there tax consequences of that? Is because the wife is going to get the Audi A4, but is actually a company asset, and she wants to keep that and that's part of the deal. Happy days. What is the taxation consequences of that? Does that affect the value of the business? Will the other partners or the other directors of the company sign off on that? Yeah, it can be difficult.
Yeah.
Absolutely, it can be. And also, I guess, even outside the family law aspect, Josh, just in terms of, your insurances, your estate planning, things like that, separation can have, a lot of implications that can be a ripple effect. Yeah. So again, going back to your dream team, there's likely no one-stop shop. You will, I say, see a lawyer first, but you'd probably say, see a financial person first. But swings and roundabouts. But as long as you're getting the advice to cover the bases, you should be right. But you're right, it is tricky. It does provide another level, another layer of complexity that you need to work through, because parties need to know. Like I said, parties, sometimes the intention of an agreement or the intention of an outcome or a resolution is very simple.
Yeah.
Sometimes to achieve that simple intention requires a lot of complicated, complex orders. Do you know what I mean? So it's simple, we just transfer the trust to me or something like that. To actually affect that is very, very complicated. And as an advisor, part of our role is to try and convince people this is why it's complicated. And trust, I'm not just trying to take your money and make it hard for you. I'm not here to cause problems. I'm here to fix problems for you, but we just can't quite go in that direction. It's not as simple as what you may think it is. And these are the reasons why. Or this is who we need to pay to make it very clear to us to make sure that what we're actually doing realizes that intention.
No, huge. And I was going to ask you one final question around like people going through a big change in their life. What should they do, or do you have any advice for them? But I think it's no different than what we do in the financial advice game. Like if you're ever unsure, just speak to a professional and have a chat about your situation, and then I'm sure you would guide them in terms of, well, do you even need a family lawyer, or do you need another expert that can give you the solution that you want? Would it be as simple as that?
Yeah, absolutely that is. And I just think, on a personal level for people, especially like in a family law context with separated couples, I think, first of all, stay safe is what we need to do, but also stay calm, do you mean? And try not to be emotional or get sucked into the vortex. We get a lot of people that lose sight of the forest through the trees. All they can see is the affair, or all they can see is the message that was passed through the child, or all they could see is the drunken text messages or something like that. And they get really involved. Right? When it comes to property matters, at least what we've been speaking about, mostly today, that can be separated. Nowhere in that 4-step process or in the Family Law Act does it say who's slept with who, or who's been unfaithful, or who's the morally inferior person. It's not actually about that. So the things that people are worried about or focused on is not actually part of the property settlement at all. With parenting, it's a little bit different because there can be some crossovers. But again, I would remind people to be child focused because people can be really terrible partners, but be really excellent parents, and just try, even though it's very hard, just try to remove themselves from the situation and think with their head and not their heart, which is not easy to do. It's easy from the cheap sheets, it's cheap seats to be able to advise that, but it's not easy to do when you're in the moment.
No, that's amazing information, Ben, and really appreciate it today. And before we then wrap it up, where can the listeners find you if they actually do want to chat about their own situation? I know you have a podcast. I'd like to just hear about the podcast that you're running there, but where can the listeners actually find you if they do want to chat?
Well, I guess, Josh, the easiest way is our website, Bryant-Mckinnon.com.au, and I'm sure you'll put a link to it on your podcast page. But that's probably the easiest way. And we do have heaps of resources on there, that are available. A lot of them are like the court prescribed brochures about marriage, family separation, and what to expect when going to court in different court events and things like that. We have like a resource page. But like you mentioned, Josh, we also do a podcast quite like this one called The Family Matters Show, and people can get that wherever they get their podcasts. Or again, there's a clear link to that on our website. We're up to 50 plus episodes or something now on that. Amazing. And the intention, and I guess Josh, it's like this, your intention with doing this podcast is we're trying to get information out to the public early, right? Because it's very,
Yep.
you can listen to podcasts anonymously. Seeing a family lawyer can be very frightening. Seeing, anyone and it's telling your story sometimes is the first time to the family lawyer. It can be very intimidating. And sometimes what I would say, people, see the lawyer too late. But, a lot of stuff has gone down already before they even seen a lawyer. So I think it's really important to try and get the information out there as soon as possible so people can start making informed decisions as soon as possible. Podcasts do it in a free way, in an anonymous way, in a safe way. So that's our intention, is trying to just educate the community and trying to help them make some pretty important decisions in some pretty rough times.
Yeah, no, amazing. And people in other states, they can just, like we're talking here on Teams, they can just speak with you on Teams. There's no restriction on that. They don't have to obviously be driving up to Coffs Harbour.
Absolutely not. But we're more than welcome. You can, there's plenty of room. But what I would say is also, and don't let the different states thing trick people. A lot of people think something magical happens between the borders. It doesn't. COVID is over. Essentially, the Family Law Act is a federal jurisdiction. The laws that apply in Melbourne are the same laws that apply in Sydney, the same laws that apply in Coffs Harbour, same laws that apply in Brisbane. Okay, so nothing magical happens over the borders. The advice that I can give your listeners or the Victorian residents is exactly the same advice as that I'd give someone here in Coffs Harbour.
Yeah, no, amazing, mate. We'll finish it up there. That's all we got time for today, guys. And this was awesome. I actually learned a lot from this one in itself, and I'm sure there's going to be more podcasts we could do on different topics that are already running through my mind. But I don't want to keep us on here for the next couple of hours. So we'll put the link to the website in the show notes, Ben. And of course, if anyone does want to have a chat, just feel free to jump on his website, follow the podcast that they're running. And of course, as I always say, if you want to chat about your personal situation, feel free to jump on our website and come through to any of the advisors for the chat. Ben, really appreciate your time, mates, and hope to see you again on another one.
Perfect. Thank you.
Done. Thanks, Ben.